Good afternoon, ladies and gentlemen, and welcome to the planning part of the authority meeting. We will begin with being brought up to date with item 19, which is the appeal on Little Acres at Brendan Hill. Watch it. Many of you will remember this was a very controversial site and application, and we have received a most interesting appeal decision.
Thank you, Chair. As the Chair just outlined, this is a site that many of you will recall as being a site that sparked quite a lot of local interest. There was quite a lot of correspondence, not just with the authority, but also with other national parks, and the concern that the precedent of any approval of the application would bring in terms of the scale of the development and the size of the land holding involved. So it was on a parcel of land of approximately 4 acres, and the application sought part retrospectively the establishment of a rare breed poultry farm and horticultural business, and it involved the temporary siting of a caravan, 2 polytunnels and 3 buildings, together with the installation of solar panels and the construction of 2 dew ponds. The site attracted 2 planning applications during its life. The first in 2021, which was the matter at hand with this current appeal, and there was a later application in 2022, which changed some of the siting of the building to try and overcome some of the landscape concerns that was raised on the original application. It did include the submission of an ecology report that was missing on that first application, and also looked to strengthen some of the arguments, which was around vertical farming. So they were looking to carry out vertical farming in polytunnels, and they were looking to produce a business that was off-grid, for want of a better word. They were looking to do using hand tools rather than mechanical tools. They were looking to use, instead of machinery, to help with the incubation of eggs, but to manually turn the eggs during the process. And it was felt that that added some additional labour requirements that would justify the granting of the planning permission. As I touched on earlier, the application was part retrospective. During COVID, the appellants had moved on to the site. They'd done some works to the access, and they had started to erect some de minimis buildings for chicken coops, and some framing for the solar panels. The solar panels were later brought onto the site. You will see by the papers that the appeal was dismissed, and it was an interesting hearing. So it was heard by way of an informal hearing. There was much debate at the start of the proceedings around the information that the inspector was considering. During the life of the application, and actually both planning applications, there was quite a lot of debate in terms of what information should be in the public domain by way of a business plan. The appellant had sought to remove reference to any financial details, so was looking to keep everything financially confidential. Where we were looking to take a more pragmatic view, there were certain elements, of course, associated with the business that we were looking to keep confidential, but there were certain things that we felt that should be in the public domain. We had to rehearse those debates with the inspector, and we also had an agricultural consultant who helped with that process as well, and who was very helpful to sort of unpick what was quite a challenging discussion. After that, we went through the main themes of the appeal. One matter that we didn't contest was around ecology. As I said earlier, the 2022 application actually submitted an ecology survey, and the findings of that by our consultants and by our in-house experts was that overall there was no detrimental impact upon ecology. So we said that we would not be disputing that reason for refusal. But on the other grounds, which were namely the principle of the development, the impact upon the landscape and highways, the inspector, as you can see, felt that there was not sufficient evidence to show that the the requirements of the farming enterprise was required, that the labour requirements, were necessary to sustain somebody living on the site, nor did they feel that the business was financially able to support somebody living on the site. They made reference to the purchasing of machinery that would be required and stock, etc., etc. And they also felt that the proposal that before the works had taken place was an open, undeveloped field also led to a detrimental impact upon the character and appearance of the landscape. There was 2 or 3 particular viewpoints where you could view over the field and see the site in the wider context. It was quite interesting insofar as there was one viewpoint in particular from the main road at the top running past Treba Common, where you could see it in a gateway. And the inspector, despite there only being glimpsed views and limited opportunity for people to be stood there and enjoying that view, felt that that was quite an important vantage point, bearing in mind the significance of the landscape which we find ourselves in. There was also another view as you arrived to the site via the highway, which had been opened up through normal forestry practices, which had removed quite a lot of the tree coverage that had previously screened the site. And again, the inspector sided with the planning authority in recognising that harm. The inspector, however, did feel that the highways concerns that were raised could be dealt with by planning condition, and that was by way of sort of trimming back hedges, creation of hard standings for visitors to park on the site and to be able to manoeuvre within the site and leave the site in a forward gear. So those weren't matters that the inspector felt warranted refusal. However, this is a very important decision for us, bearing in mind the amount of resource and interest it sparked. So it's certainly a good decision and one where the inspector has gone quite methodically through the thought processes, and certainly one for officers to take away and have a think about. There was also an associated cost application by the appellant on this one, and it was felt that that didn't succeed. I will add. The only thing the inspector did say that we would bear in mind for future applications is that she was somewhat disappointed that we hadn't resolved the issues around the information being made public before the hearing. So that was I think a fair point on that behalf. So all round good decision. Happy to take any questions. Thank you, Chair.
Any points that anyone would like to raise on that? As you know, it's been a long-running issue, and indeed one of the neighbours brought it to the consultative forum as an issue because of the precedent it might otherwise have set. But Dr. Kelly.
Yes, thank you, Chair. Well, our thanks to the Principal Planning Officer and also to our consultants who did very well. It's a very important case because whilst each one, as we know, is determined on its individual merits, there will be others similar to this, and other rural authorities are also experiencing similar applications on small parcels of land. In terms of any functional requirement, it came to all of 0.18 standard man days, so it fell far short of what would be required. In my view, the inspector, and I've come across the decisions by the same inspector before, it's a very sound decision, identified all the material considerations and weighed them up correctly. So well done to Principal Planning Officer Dean and also to Land Sense for their support. It's a very sound decision. Thank you.
Indeed. Right, Mrs. Nicholson.
Endorse everything that's been said, absolutely. I think, though, that those of us who were at the meeting, not called by us, but called by parishioners, will reflect on how outrageously unpleasant 1 or 2 of them were to the applicant in a public forum, in a way that it was quite difficult to stop. We did stop it in the end, but it was quite difficult to stop it, and it's no reflection on the park, but I think actually it's something that perhaps we need to think about for the future as to whether there's any. Dean, you remember, it was awful.
As you say, though, Mrs. Nicholson, it wasn't our meeting.
No, it wasn't,
It was
but-
something that we could only observe happening. But yes, feelings locally did run extremely high, and you're right. The applicant behaved with considerable dignity in the face of some very significant local objection.
And very significant local provocation, which he felt designed to make him lose his temper, and he didn't. But it wasn't our meeting. We did, in the end, manage to stop the behaviour. But whether anything about being forearmed could make it easier to stop earlier, sooner, in another...
Well, I think one of the key things that those of us that were there were forcibly reminded of was the excellence of our planning officer, because he dealt with all of the issues that were thrown at him with considerable aplomb. So, with that encomium ringing in his ears, we'll say that we'll move on to the next item, if we may. So, that is the first item of development management, 20.1, which is 615-22-104, proposed demolition of site, shop, stroke, office, information building, telephone building, and replacement with a two-storey building to house caravan site facilities and managers' accommodation at the ex-Valley Caravan site, Bridgetown. And this is going to be presented by Mr. Kinsella. Once Mr. Kinsella has made his presentation, then we'll move to the public speaking. And so the public speakers I will be calling in order of Mr. Matthews, then Mr. Takel, and then Ms. Matthews, and there will also be neighbour statements read out by the planning officer from Mr. Garner and Mrs. Garner. So they will be taken second and third. So just so you're aware of the fact that those are the public statements that will be given to us this afternoon once the planning officer has made his presentation.
Thank you, Chair. Just before I get into the presentation and the details of what's been proposed, I just wanted to flag up a couple of matters in the report that I wish to address. So, in the policy context section of the report, there is reference to HCD8 and SES3, which talk about new build dwellings in open countryside and business development in open countryside. That's an error. The site lies on the edge of the village of Bridgetown, and so therefore it should make reference to HCD3 and SES2. And just for a point of clarity, I think it's worthwhile just to take you through that policy. So again, members, when you're making your decision, you fully understand the context of the proposal. So HCD3, which is new build dwellings in settlements, talks about new build housing development will be permitted in named settlements where the site is well related to existing buildings, and any development would conserve or enhance the character of the traditional settlement pattern and the character and appearance of the site and its surroundings, and it will meet an affordable local need. And I'm going to paraphrase a little bit now just to go through the list. It will meet an affordable local need, and there is a proven local need for the dwelling, and this cannot be met by the existing housing stock. The intended occupants meet the local needs occupancy criteria requirements in accordance with HCS3, and the dwellings will be affordable by size and type to local people and remain so in perpetuity. And it then goes on about where there is more than one. Obviously, that doesn't apply in this particular instance, so I won't go any further than that. It does talk about where permission is granted at the bottom under section 3, where permission is granted for local need or accessible or adaptable housing of up to 93 square metres. A condition will be attached to remove permitted development rights. So that deals with the principle of the dwelling element of the scheme. Turning to the business side, so the office and the shop, SES2 talks about in named settlements proposals for business development or extensions to existing businesses should accord with SES1, and that's referred to in the report, and be located within a settlement or where no suitable buildings or sites are available, well related to existing buildings. The proposals will be permitted, and it then goes on to talk about the reuse of existing traditional buildings, in a way that maintains and enhances their character, or where there is no such traditional buildings, non-traditional buildings, or previously developed sites. An enhancement of the built environment is incorporated into the proposals where necessary to deliver an overall acceptable scheme. Where this cannot be achieved, a new site building may be permitted. So I want to dwell a little bit on SES2. So what we have, and I will show you some photographs shortly, is the removal of some existing timber structures which currently house an office and a reception area and a shop associated with the business. And the proposal to remove it, in your officer's opinion, would see an improvement in the built environment by having something that is more bespoke in its design and its appearance. And that's something that your officers would recommend that weighs in favour of granting the planning application. So I just wanted to take you through that. Having said all of that, and again, just before I start the main presentation, I don't believe that, and your officer's advice is that doesn't change the recommendation of the report. So with the amendments to the policies, and hopefully I've been clear in setting out what those policies are, and the report, your officer's report still stands. So I'll now go through the report and the presentation, and then I can take some questions at the end. So just to confirm again, the proposal is to the demolition of the existing site, shop, office, information building, telephone building, and replace it with a two-storey building to accommodate caravan site facilities and the manager's accommodation. The manager's accommodation is currently by way of a caravan on the site, and it's shown here on the photograph with the associated timber buildings next to them. The site itself, as I said before, is on the edge of the village of Bridgetown. The application site is over a relatively large area, but the application site actually is towards the south of the site, close to the centre of Bridgetown itself, and I've got some more plans to follow. This is an aerial image just showing the site. You can see the general layout of the campsite itself, and you can see a hard standing here which represents the area of where the functional buildings are located. The main A396 runs along its eastern elevation, and there is a minor road highway which runs to the south. There is also a watercourse that runs adjacent to the property, and I'll touch on that a little later. So this slide shows the existing block plan against the proposed development. Again, I would just draw members' attention because it's probably quite small on your screens. My cursor here is showing where the manager's accommodation currently is, and it's in this location where the buildings are which are proposed to be replaced. Highlighted by the green line shows the outline of the proposed new building to accommodate the proposed development. And this again just reinforces some of those existing elevations. You can see by the photographs at the bottom of the site, you can just make out that they are pretty standard timber structures, and they are located next to the manager's accommodation. You can also see at the bottom left, you can see the outline of the proposed development imposed against the existing space taken up by the various uses. So this slide shows the elevations of the proposed two-storey building. The proposal seeks to utilise the ground floor for the reception, office, telephone and information board area, with the residential unit staff accommodation at the first floor, which occupies around 88 square metres, I believe. The use of materials are considered to be acceptable. There's some timber cladding render. There appears to be use of solar panels in the design, and overall it is felt that the design would see an improvement upon the character and appearance of the area. So this slide now shows it in context in associated with the flood zones. You can see that the site itself, and in particular the application site, is fully within flood zone 3B, with the exception of a small area along the eastern side, which is in flood zone 2. Flood zone 3B is recognised as being the most significant area in terms of floodplain. It's functional floodplain, and the guidance within the MPPF, within the planning, the PPGs and our own policies talk about development should not be allowed within flood zones 3B when they are of a vulnerable use. And I've got a slide shortly just to illustrate that a bit more clearly. But just shows it in context in terms of thinking about alternative sites when we get to the end of the presentation. So I've got a series of photographs now, again just putting the application site in context. I've shown you a few examples of this, but this is the manager's accommodation and the associated buildings and information boards. This is just taking it into the slightly wider context, and again looking up the site in a northerly direction. The hedge which bounds the highway you can see here, which is a mature hedge running along, which screens the site from views as people drive along the highway. And this is taken nearer the site, again just looking in a westerly direction towards the boundary there. So I touched earlier on about the fact that the site was in flood zone 3B, and this slide is just to illustrate the fact that first of all a more vulnerable use is listed and includes and is highlighted buildings used for dwelling houses, student halls of residence, drinking establishments, nightclubs and hotels. And less vulnerable talks about buildings used for shops, financial, professional and other services, restaurants, cafes and hot food takeaways, offices, general industry, etc., etc. But then when you look at the incompatibility table at table 2 on the right hand side, you can see that in flood zone 3B it talks about highly vulnerable uses, or more vulnerable uses, being development should not be permitted. Also excuse me, I would also draw the attention to the fact that the less vulnerable use, which is the office and shop use, is also identified as development that should not be permitted. So that provides you with some context in terms of the guidance that is available to us alongside the planning policies that are set out in the report. This final slide, or one of the final slides, I got one afterwards just thinking about it, it just sets out the reason for refusal that's set out in the report, just to remind members of that. I won't read through that, you can read this at your leisure in your papers. So, in conclusion, I would draw members' attention, first of all, to the recommendation at the end of page, at the start, sorry, of page 12 of the agenda item. And then I would also draw members' attention to the consultation responses from the Environment Agency. Firstly, they commented on the 6th of December in 2022. And within there you can see that they objected to the proposal on the grounds there was insufficient information. They invited a flood risk assessment and then before determining the application that we needed to consider the risk regarding the sequential test. And again, you will have read that, I'm sure. I then draw your attention, in December of 22, it's also worth noting that towards the end, it talks about advice to the local planning authority, and it says, we will maintain our objection to the applicant supplied information to demonstrate that the flood risk posed by the development can be satisfactorily addressed. We would like to be reconsulted on any information submitted to address our concerns, and we will provide you with bespoke comments within 21 days of receiving formal reconsultation. The applicants then submitted the necessary flood risk assessment, and then in March of this year, the Environment Agency responded again to maintain their objection to the proposal. And I think the wording within the response is particularly important, and members need to give due regard to. It says, we object to the proposed development because it falls within a flood risk vulnerability category that is inappropriate to the flood zone in which the proposed residence site facility is located. The application is therefore contrary to the National Planning Policy Framework and Planning Practice Guidance. We recommend that the Planning Permission is refused on this basis. And then it goes on to talk with the reasons, and it says, we have now reviewed the submitted flood risk assessment and we advise that the proposed building would sit within Flood Zone 3B functional floodplain as defined within the PPG as land where water from rivers or the sea has to flow or be stored in times of flood. Evidence of historic flooding on the upper X and the specific location in question categorically confirms this position, as indeed does the applicant's flood risk assessment, which shows the area having flooded in January 23. I thought I'd put a slide on because they'd included an image there, but for some reason it's not been included. And then just to again draw members' attention on page 5, under the title Overcoming Our Objection, it goes on to confirm that given the above, that the planning policy confirms that more vulnerable development is not acceptable within Flood Zone 3B. We do not foresee how we will be able to alter our position on this particular proposal. The applicant may wish to reconsider a proposal for a like-for-like replacement on the same footprint. And I wanted to finish on that because that's a statutory consultee with expertise around flood risk. And while there are benefits associated with this proposal, the authority officers and members are encouraged to give significant weight to the response of the Environment Agency in objecting to the proposal. And on those grounds, unfortunately, officers have had to recommend refusal to this proposal. Thank you, Chair.
Right, thank you, Mr. Kinsella. So we'll now move to the public speaking part of this item. And our first speaker is Mr. Matthews. Mr. Matthews, if you'd just come and take a seat at that table in front of you, if you could just make sure that the microphone is on at the top. There's a button at the top. And you'll have 2 minutes from when you start to speak.
Well, good afternoon, and thank you for allowing me to say a few words. When I was 65, I retired, and my wife and I moved to Exmoor. That was 20 years ago, so you can guess how old I am now. We bought Bridgetown Mill, the mill house, and the campsite. And indeed, looking at the mill, or what we found in the mill, was that when it does flood, and it doesn't flood very often, but when it does flood, it's designed so that the water flows in and flows out, and it's been there for 400 years. So it was obviously a good design at that stage. My wife and I ran the campsite for 7 years ourselves. Then we appointed wardens who ran it for the next 9 years. The wardens lived in caravans on the site. And now my daughter, for the last 4 years, this is her 4th year running the campsite, has taken over from the wardens, and she lives in the caravan that we saw in the slide, and has to move every 6 months because she lives there during the summer and lives in the house with us in the winter. That does cause a problem, having to move house every 6 months. We set out to make a number of improvements to the site. We managed to get the mill working, which was very good. We've spent a lot of attention on the groundwork to improve the site appearance. Everything that needs to be painted is now painted regularly. The showers and the toilets have been totally refurbished, and we're now able to run mill tours for the campers on a weekly basis every Sunday morning. We had a big problem with ash dieback, and the numbers of ash along the river bank had to be taken away, and we've now replaced these with planting of 200 saplings. We hope at least 50% will survive, which is a fairly good number. For the future, my wife and I have to consider our age, and at some stage we won't be here, and the house will be left to my 3 children. Tonya is one of them, but the other 2 children as well. And in order to divide it up, it needs to be divorced from the campsite. At the moment, there are 4 items of electronic equipment in the house which run onto the campsite, and the basement of the house is used as a storage for the shop.
Mr. Matthews, I'm sorry to interrupt, but you've had 2.5 minutes now. Do you think you could possibly just bring your remarks to a...
Yep, these plans,
Thank you.
I was just going to say, these plans provide the best solution to the problems that need to be resolved. Thank you.
Very elegantly concluded. Thank you very much. Thank you. Right, I'm now going to ask the planning officer to read the statements by Mr. Garner and Mrs. Garner. Oh, sorry. Mrs. Garner and Mrs. Garner. 2 Mrs. Garner. I do beg your pardon. Mrs. Garner and Mrs. Garner.
Thank you, Chair. So the first statement is further to my letter in November 2022 regarding the above application. We were flooded in January 2023. The force of the water coming through the caravan site was horrendous and terrifying. If a permanent building were there, it would probably push more water onto my property. If it were further away, as I suggested, it would possibly not impede the flow, with the building itself being protected from flood water by the bank. The shop and the caravan, being the original footprint, were significantly flooded. Even having tanking fitted to the property might not help, as I have recently found out that my house is still getting moisture in the walls, so much that it rots the back boxes for the light switches. As I said in my previous letter, I'm not opposed to the building itself, just the siting of it. Moving it to the other side, nearer the flood bank, could be a benefit, given the chances to enlarge or alter the entry drive so that large vehicles can negotiate the bridge and entrance easier, hopefully not damaging the bridge or vehicle as has happened before, now that camper vans and caravans are getting larger. That's the end of the statement, Chair.
Thank you. And then there's the second statement.
With reference to my previous letter, reference 6/15/22/104, I would like to add that on January the 12th, 2023, the caravan site and neighbouring properties unfortunately flooded by a significant amount, and in my opinion, the proposed building and siting it will be on will need further investigation to see if there may be further impact in the future. I would also like it made clear that I am not objecting to the planning application, but wish it on file that I am concerned about the impact of the flood risk an additional building could have in its current location and the neighbouring properties who are affected by flooding. That's the end of the statement, Chair.
Thank you very much, Mr. Kinsella. Our next public speaker is Mr. Robert Takel, and Mr. Takel is a member of Exton Parish Council. And are you speaking on behalf of the Parish Council, Mr.
Yes.
Takel? Yes. So again, you'll have 2 minutes from when you start to speak.
Is that on? Yeah. Thank you, Mr. Chairman. As you've heard, my name is Robert Takel. I'm here to represent Exton Parish Council. The application for the proposed new building at the Ex Valley Caravan Park has been discussed at recent Parish Council meetings, and the Council unanimously is in support of the proposed development. The Council is always very supportive of local businesses, and this long-established business has become an important and integral part of our local community. With our village hall being somewhat inaccessible and the local public house operating very limited opening times, the caravan park has become something of a hub of the community. Tonya and her family have hosted numerous social events at the caravan park, the most recent being the very well attended celebration of King Charles's coronation. With regard to the proposed building itself, there is a proven need for a local shop, not only to serve the caravan park but also the local community. This was very evident during the COVID lockdown when Tonya's shop became a crucial lifeline for many. The shop and caravan park not only provide employment for at least 6 local people, but also is an important outlet for local producers. I think there are now around 15 local businesses supplying the shop, and with better premises this can only increase. The application is to build a new shop and manager's dwelling on the site of the existing setup, which, as you've heard, consists of 3 wooden huts and a touring caravan. The view from the parish council is that a well-designed building with modern flood mitigation methods incorporated would be a great improvement on what is there already, both from a visual aspect and from the point of view of the flooding risk. And it would have no adverse effect on any other property in the village. So, the parish council would ask this committee take a pragmatic view of the application and consider the positive and beneficial aspects of the planning application, which in all respects outweigh any negatives and would have considerable benefits for not only the caravan park, but for the whole community. Thank you.
Thank you very much, Mr. Jacob. And our final speaker is the applicant, Ms. Matthews. So if you step forward to the table, and again, Ms. Matthews, you'll have 2 minutes from when you start to speak. Yes, it should still be on, so far away.
Thank you. We are a family business established in 1971 by the Sharing family. We provide full or part-time employment for actually 8 people, as well as well over 20 tradespeople and suppliers who support us. Our staff are first aid trained, and there's a defibrillator on site which is used by the village and the campsite. This year we were awarded 5 platinum pennants from the AA, which is their highest grading. We attract visitors who love what Exmoor has to offer, and we have a good returning high spend customer base of between 3,000 and 4,000 visitors every year. We support and promote Exmoor whenever we can, and I have spoken twice on BBC Radio Somerset to do this. Our proposals will reinforce the future viability of the business. Growing the retail side will provide more employment, and it will allow us to operate the shop more efficiently. Providing on-site managers accommodation means the business can improve its service to campers with better security and ensure emergency help is readily available 24 hours a day. I need to be able to access the site easily, particularly as I'm slightly disabled. A modern dwelling will reduce energy consumption and be less of a drain on the long-term finances. The shop is well supported locally, and this reinforces friendship in the community and has a real benefit for people's mental health. During COVID, we took in prescriptions from Exmoor Medical Centre, and I made deliveries to people in the village who were shielding. We know the site floods. Our plans have been drawn up to minimise and mitigate against the effect of floods. A brick building will not float away and block the river. In January, we measured the height of the largest flood we have seen, and the building will be waterproof to 35% above this, and is probably good for the foreseeable future. All accommodation and plumbing will be on the first floor. We are confident it will not increase the risk of flooding to any other property in the village. Should we have a flood warning while the site is open, I want to spend my time helping the guests rather than worrying about my caravan and shop stock. So in summary, our plan provides a pragmatic approach to improved efficiency of the shop, a better service to our visitors, and good mitigation against the effects of flooding. Thank you.
Thank you very much, Ms. Matthews, indeed. So, members, the debate is now open. A difficult application. Dr. Kelly.
I wasn't necessarily going to start. This is a very finely balanced application. Just a couple of points, if I may. In terms of what is authorised on the site, there's an implication that the existing caravan, residential caravan, would be eligible for a certificate of lawful use. Can I just clarify that point?
That's officer's informal view. That hasn't been established by way of a certificate of lawfulness, but obviously it would be open to the the applicant, should they wish to at a later date, should the application be unsuccessful, to be able to establish that and take it forward on that basis. But there is no planning history.
But just going on from that point, it is open, as you say, for the applicant to establish the lawfulness of a residential unit on the site, subject to going through due process. And then we come on to the Environment Agency. It talks about at one point, the applicant, sorry, this is on page, I don't know which page it is, page 5. The applicant may wish to reconsider a proposal for a like-for-like replacement on the same footprint. Could you just clarify what the EA, are they actually suggesting there is a way forward here?
So officers' reading of that is that they would literally look to replace the building's structures and use exactly as it is now, but just with new structures. It wouldn't necessarily demonstrate an ability for them to be able to add a structure to it. I don't think that the EA is saying, well, providing you are where you are, that you would be able to benefit from a new building, because of actually, on the face of it, what you've got before you, in terms of the overall footprint, isn't significantly apart in terms of what's being proposed and what's currently on site. I don't have the figures in front of me, but I would suggest they are comparable.
Just in response to that, it seems we've got to, obviously the government, the EA are the government's flood risk agency. They are tasked with making sure that no development in the vulnerable category, or less vulnerable, should be approved without good reason. And I know this from my own experience, every year a planning authority was required to provide returns to the EA of any recommendations against which it made decisions contrary to the EA recommendations. So it's an important point, it's part of the performance measured of the authority in dealing with its statutory consultees. So it's not a trivial matter to be lightly set aside. And I just wonder, given the points that have been put forward, whether there is a compromise here. For example, for a certificate of lawfulness, a unit is approved on site as a residential unit, and taking into account the associated structures, which I think the EA referred to, whether there's a redesign that would not lead to any increase in displacement of floodwater. And I just wonder whether that's been explored in order to try and find a way of meeting these objectives. I'd appreciate any comments on that.
To my knowledge, there hasn't been the detailed discussions that you've referred to, but obviously as part of a process you can see by the start of the report, this application has been with us for some time. The Environment Agency have had considerable time to consider both the initial submission and then the findings of a flood risk assessment, which explore those very things that we are talking about in terms of what are the options. Now, the flood risk in this instance talks about the depth of the floodwater. It talks about the fact that the building could benefit from being above that floodwater in terms of finished floor levels. And based on that, you have a response from the Environment Agency, who is going, not just saying we object to it, he's also saying later on, which is why I made the point, they are saying, and we don't think we're going to be convinced otherwise here because of the significance around flood zone 3B. Now, we all have sympathy for the applicants here in terms of what they're trying to achieve, and that's why at the start of the presentation we did touch on the benefits of the scheme and what it would bring, because I wanted to make sure that members understood, that officers understood the benefits that were proposed here. My concern is that we could go back to the EA under this application and spend a lot more time and effort into something that comes to the same conclusion. It would feel more appropriate to me at this point in time to determine the application that's before you. That doesn't stop an applicant then going forward to the EA and having further discussions with them to see if there is any options going forward. And we will, of course, be happy to be involved in those discussions to see if there is. But given the length of time this application has been with us now, I think we almost owe it to the applicant to give them a decision to see if there is a way forward, because of we all recognise if there is an approval here, it's going to be extremely difficult. And what keeps on ringing in my ears is the EA response, which categorically says they feel that it would be difficult for them to be convinced otherwise. And I think that's a really significant statement they put in their final consultation response, which is why we're here today.
But just to be quite clear, Mr. Kinsella, the reason for refusal is entirely one associated with flood risk. The other elements of the application could have been acceptable, which is the flood risk.
Absolutely, yes.
Thank you. Mr. Elson.
Thank you. Yes, it's a difficult one, and I've got some sympathy with the parish council, even though quite often at this point one might sort of say, well, what's the solid planning reason for going one way while the officer goes the other? But actually, in this case, I think we've got sympathy because we could understand the reasoning that's been given here, and I think we can understand where they're coming from here in terms of the role of the business in the local community. I'm struck by, like Dr. Kelly was, by this idea of the like-for-like replacement, because after hearing about the exception test, does that imply that therefore an exception test isn't required for a like-for-like replacement? Because obviously, a common sense tells us that it's ridiculous, having seen a picture of what look, with all due respect, look quite flimsy group of buildings that could be washed away by a flood, and then we saw a plan for what looked like quite a solid building that is not going to get washed away by a flood. And I know there are other issues around flood in terms of displacement and so forth. However, it seemed to me that there's a difference of looking at this when it is a greenfield site on a floodplain, and why it would have to have a very strong reason to overcome that exception test in order to build in it. However, as the EA themselves says, however, if it was a like-for-like replacement of your existing group of buildings, that would be fine. Well, surely that doesn't make sense if your like-for-like replacement is as flimsy as the buildings you currently have. And so I'm not very convinced by the EA's reasoning. And the trouble is, if I'm not convinced by the EA's reasoning, and that is our only basis for refusing the application, that does put us in a rather difficult position. So what I'm now coming to is saying, you, as you have before, and we always absolutely take this very importantly, and I totally understand what you're saying, about giving significant weight. In a way, what I'm saying is, under what circumstances are we able to, having given significant weight to the EA's recommendation, to then decide that actually, in this case, we won't go with their recommendation? Thank you.
Interesting one for you there, Mr. Kelly.
Well, actually, it's quite a nice easy one for me, because that's not my job. I'm here to advise you. Your officers are here to advise you on what we believe, and we believe that's a significant consultation response. So we've given weight in our report, and we go, we don't think there is a necessary solution here that meets the requirement of the applicant. I guess it's for you guys to sort of sit there and go, okay, what can I think about? How can I think about it? And there are things, and we've talked about them in terms of the other merits of the scheme. They always carry weight in the decision making. The materials that are used, they always carry weight in the decision making. It's supporting the local business. That always carries weight in the decision making. And you build a picture. I would always come back to the fact that you've got a government's consultee, a statutory consultee, who goes, we recognise all of that. They will have seen everything that you guys have seen today, and have given due regard to all of those things, and still gone, but as a matter of principle, we think this is wrong. So we can read into some of the comments, and we can pick out the sentences that help our argument, can't we? So I appreciate I'm doing that here, but it's that again that I would repeat, where they say they don't think that their position will be altered. So regardless of the fact of a like-for-like look at it, they're saying, actually, we still don't think we're going to be changing our mind here. We think it's so significant. And yes, there are further discussions that can be had. But I'm conscious about, real life things like money and time and expense of going through that, and sort of giving some form of a decision here today, I think would help that process. And as I said, the door is open to have further discussions with you to see if there are some options that we can look at. But I think for the purpose of making a decision, I think we need to take that on board. Unless, obviously it is open to members to direct officers to go away and have further discussion. And of course we will.
I think I would say we're between a rock and a hard place, but I think it's a rock and a wet place. Dr. Warren.
It was just a point as well, because I think, yes, it's very finely balanced and the positives have been very well put forward by the public speakers here. So in terms of flood zone 3B, essentially, can you put flood mitigation measures in place that would mean that kind of building would be acceptable, or is what you're saying, Dean, is this kind of at the end of the day, there's no way they would let that happen anyway, in their view?
At a national level, the EA normally say if you're in flood zone 3B, you shouldn't be developing on it.
Right.
That's their general rule. Now, there are always exceptions to that, and I'm sure we could all go away and quickly find where that has been, that decision has not been taken. But in my experience, to get to the point where you can get development on a site, it normally requires a lot of time, and I'm talking years, and a lot of expense. And you have no guarantee at the end. So I guess for us, we're trying to make a decision here based on what we've got. And you know, without repeating myself time and time again, the response was so strong that we felt actually it's not helpful to continue a discussion. We need to come to a decision.
So the applicant has done what sort of practical, pragmatic in terms of design, in terms of what have they described in terms of mitigation, and that's what's practical and possible, but that isn't.
There's probably always more you could do.
But
and
time, money, expense.
Yeah.
Okay.
Mr. Petrinos.
Yeah, thanks. Yes, as everyone said, we've got all sorts of sympathy for the applicant, and it's very, very finely balanced. But we've got this bridge that's impossible to cross when we come to the Environment Agency advice. And even though we try and read into the wording of it, really it comes down to what Mr. Kinsella said about them saying they can't see how they could change their mind about it. So I'm going to have to move the recommendation. Sorry.
Right, thank you. Is that seconded by Ms. Stacey? Okay, so it has been moved and seconded now, but I still have other members who wish to speak. Dr. Kelly.
Yes, thank you, Chair. If we look at the most recent response of the Environment Agency, I think we could say that we're minded to approve it, but it does say, if you are minded to approve the application, contrary to this advice, we request that you contact us to allow further discussion. And I think we're all struggling with what the Environment Agency means when it says the applicant may wish to reconsider a proposal for like replacement on the same footprint, because that to me implies that there is a solution here. And I think it would be reasonable to go back to the EA, and I do respect what you say about deferring it further, but to say, well, there was a disposition, we were minded to approve it, or some members were, but we do need to consider further what you mean by this, because it does imply that there might be a solution. So if we're able to make a resolution to that effect, I would move that.
Would it, however, and I'm really speaking to Mr. Kinsella now, would it, in your view, be better for the applicant for us to accept the motion that's been moved, but know that the applicant can still reapply within 12 months for free? So those discussions can still be held, having had that decision, but we can still carry on with the discussions, the refusal having been given.
It's sort of an impossible question to answer, because if those discussions were very quick and the applicant got the decision they liked, then I guess they'd turn around and say, no, we'd rather keep the application in and we'll get it back to committee in a couple of months' time and we'll move forward. If those discussions are long and protracted and lots of sort of surveys required, then maybe they would say yes. I think we've discussed it as much as we're ever going to be able to discuss it here today. I think you've got a motion on the table that's in line with the officer's report, recommendation. I think you've got potentially an alternative motion, which would be an amendment, and either that follows on from the first vote or not. But I sort of I don't think we can take it much further today. I think as members, you know, you've been clear in your sympathy with the applicant, and there seems to be a wish to explore every option that we possibly can, but I'm not sure we can debate it much further. if
We
I'm honest.
don't have a solicitor here, do we? I think I'm right in saying that what Dr. Kelly is saying wouldn't really be an amendment because it would effectively negative the motion. So the procedure would be, unless there is some amendment that comes forward to it, it would be to take the vote, and then if it falls, we've got the opportunity to pull it again. Yes, exactly.
Chair, if I may, if it's going to clarify matters, I'm quite happy to withdraw that motion.
I've still got some speakers, however. Mrs. Chilcott.
Thank you. Can I just understand, you said earlier that they could apply for a certificate to say, because it has been lived in that area, albeit in a caravan for some time, they could apply for that certificate. Would that in turn make any difference if they then apply to put a permanent building, because you would still have the flood risk in place?
It would be helpful to have that clarified, actually.
It would help in terms of establishing the use of land. So you would be turning around and saying, look, there is already this use happening here. And I think this might be where the EA are talking around for the like-for-like proposal, where they're saying, okay, so you've got this, which is what the certificate would show, would be a rectangle, for a better description, of land that says that's your residential use. And they say, okay, put your residential use there. And that might not meet what the applicants want, but it was established that. And then I think anything outside of that, the EA would probably, and I appreciate I'm speaking on behalf of the EA and I might be completely wrong, but I think that they would say anything beyond that, you're adding that new risk. And so it would help to establish a use, but only in so far as the use that it establishes.
So that could bring us back to exactly where we are now, effectively, so it might not help the applicant. And the only other question I would ask, and again, new to planning fairly, so we've got a certificate of existing use that was issued some years ago for caravans and tents on the site. I'm trying to understand how that was agreed, yet a more solid structure, which in terms of life and limb protection in the event of a flood would seem safer, how that could be agreed, yet a permanent building can't be. That's my struggle.
So because that was by way of a certificate, that's more of a legal application rather than a planning application. So you don't assess those on the basis of their accordance with the local plan. You assess them based on evidence for that use to be taking place for a number of years. And in some circumstances it's 4, in others it's 10. But once you've established that use, you get a certificate that basically goes, the planning authority cannot enforce against that use, and so therefore it establishes it. But what it doesn't take into account is things like the EA, who might turn around and go, but this is flood zone. We would have to go, from our point of view, we have to grant the certificate. And there might be other legislation that will deal with other things, but we won't necessarily be involved in that.
Thank you. It's just hard to understand from a public point of view if you've already got people effectively living on that site, albeit seasonal.
Are there any other members who wish to comment or offer insights? Mr. Milton.
Slightly hesitant too, but I think probably ought to. Sitting here, can sense a dilemma on everyone's minds here. Is that feeling that we have development here already? There is an established use. And it would appear from the footprint that it's not additional development, it's a development that's on a similar scale and size, albeit that the established use, the certificate of lawful use hasn't been established as yet, although it would appear from the time scales that we've been given that would be feasible. I've got a dilemma in my mind here really, and I kind of feeling has logic departed from the EA when they assess this, looking at what's there already and where the opportunity lies potentially for a design of a building that may mitigate a problem, rather than ensure that we just keep what's there regardless, whatever the problems it may create and whatever the impact on local community. I've got quite a dilemma in my mind. I must admit, material considerations elude me at the moment to be able to look at this one, but I'm kind of trying to work out where it fits on the terms of development when there's already development here that it's replacing. So, hence my dilemma.
A number of you have touched on it today. It's just worth clarifying that sometimes the issue with development within flood zones isn't necessarily just the fact that you've got some buildings that can be washed away and then you provide something more substantial. Sometimes that more substantial building can be the cause of the problem. And that's what we don't get in the response. So it might be, and I am absolutely guessing here, so this isn't a matter for you to consider in making the determination, that they say actually what you will do is you will offset that, and actually what you're doing is you're okay, but you're making it worse for your neighbours, which is something that the comments that I read out are concerned about. So they're saying, well actually this could cause me a problem, not necessarily the applicant. So it's just worth having that when you're thinking about that overall impact upon the floodplain.
Right, Ms Stacey, you seconded the motion and you want to speak.
Yes. Very briefly, the EA are going to be looking at their legal responsibilities as the flood authority, and they'll be looking at things like 1 in 200 and 1 in 300 year floods, and what the construction of another building on that site might then be the precursor of. By not taking their written advice, we might inadvertently be taking on some of their legal responsibilities if a problem occurred. And I do think we don't have a legal advisor here today, but you know, it's a very brave organisation that doesn't take the advice of a government body in this way.
Right, I don't see any other members wishing to speak. Oh, Mrs Nicholson, your hand was not as emphatic as usual.
With apologies, Mr Chairman. I wasn't going to speak today. I am provoked to do so, I think, by a couple of comments on just remembering that the advice of statutory consultees, the consultation responses, is that the decision is ours rather than theirs. And while I know that they're very different organisations, but I do remember on a number of occasions, particularly in North Devon, there was very clear advice from highways authorities that we should not allow, for reasons that fitted what the Department for Transport told them. And for reasons that seemed to the committee right and proper, the balance was found not to be accepting the advice. So it is, I'm just saying, it is open to us to decide that there are reasons which are not, there are other reasons which are good reasons, that in such a finely balanced decision would allow us not to accept, not to act on the advice given to us. We should not think that we cannot take a different view.
Right, I've got Mrs Smith and then Mrs Lawrence.
Thank you. I'm really with Robin and many of us here. I find this a very difficult decision because of obviously the parish, you know, whenever a parish council supports things, it's usually for the right reasons and for all the other issues that were brought up by the applicant. For me, I mean, even looking at that picture, surely a lot of the tarmac that is all over the site would be causing a lot of issues with flooding rather than a permanent building, and yet that has been accepted unless it's the poorest type of you know, what you can put down nowadays. But looking at that, it looks older than what we have nowadays, which would allow floods to be pulled away from floating on the land and causing more issues. So for me, the fact that is there already, I do err on the side of supporting the application rather than rejecting it.
Mrs Lawrence.
Yes, thank you very much. This is obviously a really good rural business and you want to protect them almost from anything, because we desperately need more and more small businesses in our beautiful rural areas. So just to confirm, if we do decide to refuse today, they will be able to come back quite quickly. We will help and support as much as is possible to get them the help that they need in order to become a rural, settled, legal business that can go on from generation to generation, which is what I would like to think we are helping to do. Refusing them seems mean, but perhaps in the long term it might mean that it is a settled business that is legally running and in the right place. Am I correct?
Ladies and gentlemen, unless there is anybody else who wishes to speak, I think we've now had a very good and difficult debate. I'm afraid it isn't an easy one. It's not a straightforward one at all, much as we'd like it to be. It's straightforward in the fact that the principle, the benefit, the design, the massing are all some things that the planning department can approve of. The issue is one of flood risk, and we have the EA's comments. We can't, alas, comment about the logic of the Environment Agency. I'm afraid that's something between their minds and the minds of God. But we can only accept what they have written to us. It's been proposed and seconded that this should be refused for the reason of flood risk. You can, of course, choose to vote against that, and then we'll discuss that when the vote has been taken. But at the moment, the motion on the table is to refuse. So, unless there is anybody else that wishes to comment, may I see all those in favour of the motion as put to refuse, please? 1, 2, 3, 4, 5, 6. Those against? 1, 2, and those abstaining. 1, 2, 3, 4, 5. Right. I'm afraid that stands refused. But could I reiterate that, and I think Mr. Kinsella, you'd emphasise this, there is a willingness on the part of the planning department to try to find some resolution here that will enable the settled business to continue and to do so in a way that satisfies the statutory authorities like the EA. And there is a 12-month period in which you can come back to the authority without any further charge. From the date of the decision, which is today. So, can I thank the public speakers for being here, the applicant for being here this afternoon. You will have detected what a difficult decision this has been for everyone, and how much the members around the table feel that it is one of those issues that they would like to see resolved in a way that isn't just the straightforward refusal today, but we hope that there may be something that may be worked on with the planning department over the coming months. Thank you all very much for that. We'll just take a brief pause, I think, and allow the members of the public to leave. Thank you very much. Right, ladies and gentlemen, shall we move on to 62 41 23 012, which you'll find on page 15, and this is the Heatherville Three Tools Park, Lynmouth, and this is going to be presented by Mrs. Spears.
Chairman, could I just, I've got to declare an interest on this. I'm on the town council that responded to it, and I was at the meeting, although
so you didn't actually express an opinion on the application, and so therefore you feel able to remain and vote?
Yes, but even if I had, I would have been able to.
Yes, indeed. Okay, but thank you for making that clear, Mr. Frinos. Mr. Smith.
Thank you. Thank you. So, as stated, this is the proposed change of use of a guest house with owner's accommodation to a principal residential dwelling. The main policy consideration in terms of this, I should note at this point that the application is for no internal or external changes to the building. It is purely for the change of use of the building. And the main planning consideration, the main policy consideration is weighing it up against policy RTB3, or safeguarding service accommodation, which states that development proposals that would involve the loss of existing serviced accommodation will only be permitted where other employment uses are to be created in the existing building, or the building is to become a principal residence dwelling, and evidence clearly demonstrates that the building was originally built as a single residential dwelling, there has been no excessive alteration or extension, and the existing use does not provide an additional community service or function. Following on from that, if the clauses within Part 1 of that policy are not met, you then move on to Part 2, which involves marketing the business for 12 months, etc. In the case of the current application, the building itself has been extended in the early 1980s, but it was within, it was less than 30% extension, which is within the 35% allowable under our extension policy, and therefore officers don't believe it can be said to have been significantly extended. Sorry, bear with me. So you can see where it is on the map here, and again, that's an aerial photograph of the site. If we just come through, again, that's just a site plan and a drawing of the building as it is. If we come to the maps, the building is not present on the 1888 OS map. It is, however, present on the 1904 OS map, so it has been built at some point between 1888 and 1904. From the evidence presented to officers, the building was in use as a private residence at the time of the 1939 census, just taken just prior to the war. And looking back to the 1901 census and the 1911 census, the only property along Tors Park, the only property that was in use as guest house or hotel accommodation was the Tors Hotel. In fact, in the 1911 census, since this report was written, officers have actually seen the census summary book, which describes the Heatherville as a private dwelling, as a private residence. So officers are of the opinion that the applicant has proved that this was originally a principal private residence. As such, it meets Part 1 of policy. The Town Council, it's come before you because the Town Council have raised objection on the grounds that it doesn't meet Part 2 of the policy, the section around having marketed it for 12 months. In this case, however, that section of the policy only comes into effect where Part 1 is not met, and it is officers' opinion that Part 1 has actually been met. There was also no, because it was always a private guest house from the first application we have is in the 1970s. There were no public community functions as such, in that any restaurants or bars, etc., were for the use of the visitors to the guest house only. There was no outside public use. So in this case, because it meets that first part of that policy, officers are recommending approval.
Right, thank you. We do have a public speaker, and that is Mr. Young, the applicant. So, Mr. Young, if you'd like to step forward to the microphone, you'll have 2 minutes from when you start to speak. Is it still on? No. Could you just turn it on at the top?
Got a red light.
That's it. Thank you.
Yeah, hello there. Stephen Young, my wife, we're the joint applicants. The reason we asked to speak was because we weren't clear why the Lynmouth and Linton Town Council had actually opposed this. So we weren't assured of the whole procedure. It's only this weekend I was actually able to see the full report by the officer online. I found it. And I mean, on that basis, we're quite happy to go along with exactly what's been put forward by the officer's report, which we found very comprehensive and very fair. So I don't really feel I need to add anything to that on that basis.
Absolutely fine. Thank you very much.
Okay.
You may step back.
Okay.
Thank you. Right, we have a number of members of the committee who now wish to speak. And so I've got Mr. Elson, Mrs. Nicholson, and Mr. Ellicott. Mr. Elson.
Yeah, I'll be very quick. Very well presented there, absolutely clear. I agree with the applicant. In this case, the argument made by the Town Council appear to have not fully understood that policy R2D3 and part 2 of it, and therefore I would move to support the officer's recommendation and approve the application. Thank you.
Mrs. Nicholson.
I will second it and also say that, I certainly second it, so proposed and so second, but just to make the point, which does come up occasionally, Linton and Lynmouth have a community plan, but our policies are of a later date, and therefore if there is any conflict between them, it is our policies of the later date that have to be preferred. And that's the only other thing I just want to mention.
I think that's a good point. Mr. Ellicott.
I support everything that's been said, the proposal and the seconder. I don't see any reason why we should refuse this application. If we do, we're going down the road that if any entrepreneurial person wants to buy a big house and turn it into a guest house, or try to be successful in a guest house, they wouldn't do so if they knew that once they changed, they'd never be able to go back to a private house. So, as far as I'm concerned, it's fine. Thank you.
Does anybody else wish to speak? Dr. Kelly.
One minor matter. I think it's a misuse of the word principle in the condition 3. Needs to be checked. Apart from that, nothing.
Right. If there's nothing else, ladies and gentlemen, it's been proposed and seconded that we should accept that recommendation. May I see all those in favour? Nem con. Thank you. Rather more straightforward than the last one. Good. So we move on, if we may, to and thank you very much, Mr. Smith. Item 21, which is applications delegated to the Chief Executive. And Mr. Kinsellas will give us the edited highlights, and then we'll move to discussing them page by page.
Thank you, Chair. As my usual practice, I will try and pick out those ones that have been refused and withdrawn, and then if there are any others you wish to highlight, I will try and answer as best I can. So, without further ado, turning straight to page 3 of the item. Towards the bottom, you can see 613-23001, which is at Riscombe House. The proposal was the siting of 2 shepherd's huts and the conversion of existing field shelters to 2 kitchens and WC facilities, and the creation of pathways and associated works. This, unfortunately, was refused. It had attracted objections from the Landscape Officer, from the Exmoor Society, and from Exmoor Parish Council. There was concerns about the permanency of the structures associated with the field shelter, so the policy associated with this type of development was for alternative camping provision, and as part of that, it's supposed to have low impact, so no access to sort of mains drainage. This did. no sort of main structures unless they are conversions of traditional buildings. There wasn't a pretty significant rebuild associated with the scheme, and so there was a couple of reasons why the application was refused. Clearly, it is down to the applicant if they choose to appeal that decision, or alternatively, they may choose to come back if they feel that they can overcome some of the concerns. But as ever, we're happy to have a discussion with them if they wish to. Then, just further down on page 362502303, you can see a lawful development certificate for the proposed use of 2 caravans for residential occupation, ancillary to the existing dwelling within the farm curtilage. This application was withdrawn because during the investigations it was found that the family who were residing in the caravans had no association with the people living in the main house. While there was some suggestion that there was the use of some of the facilities within the main house, it seemed to be cordoned off, so it wasn't a communal area, it was its own separate place. Officers had come to the view that it was the creation of a separate planning unit and the creation of a independent residential use, and the applicants took the decision to withdraw that application. Now, clearly, we'll have to consider, because that use is ongoing, whether we investigate further and seek to cease that use altogether, and we'll be discussing that between ourselves shortly. On to the next page, page 4, towards the top, there is 6323003. It's another lawful development certificate. This one, unlike the previous one, maybe I should explain for some of the new members, lawful development certificates are in 2 varieties. There is of an existing use, i.e. that use is going on now, or that development has happened and it has happened some time, or there is a proposed use, which is we don't believe this requires planning permission, and this is our formal way of getting you to grant a certificate, say we agree. So you can see that the proposal was for the erection of a garden shed. It was actually in place at the time of the application, so it was retrospective, and you can see we refused that because it was outside the domestic curtilage, so it did require planning permission. We do have a planning application for this, so we'll consider that in its normal way. Then a couple down from there, 635230001, which is Higher Court Farm at Treeborough. It was for a proposed single-storey extension. It's part retrospective because the footings and part of the wall had been put in place. The proposal that was before us was not considered to constitute good design, and so therefore we refused it on that basis. We've allowed the applicant a few weeks just to see whether they wish to come back to us to see if there's an alternative scheme, but if we don't hear anything shortly, again, we're going to have to think about enforcement around that just to make sure structures don't go into place. Then on to page 5, towards the bottom, 6211230003, which is a site called Desolate. I was informed by the case officer it was an apt description. The application was withdrawn on the basis that we were concerned about the scale of the extension. I think there had either been previous extensions or the extension itself exceeded the policy for extensions within the plan. There was also a need or lack of information around ecology, so the applicant took the view to withdraw it, and they may choose to come back to us and consider us again. On to page 6, the last but one at the bottom, which may be of interest to a number of members, Bradley Pond. This one was refused. The application was for the change of use of land for the site in 4 holiday pods around the fishing pond. It was refused on a number of grounds: the impact upon the character and appearance of the landscape, the overall design of the units, which included the significant amount of glazing, and it was considered that was caused quite significant light pollution in the dark night skies. And there was also concern from matters raising from ecology. So there was 4 reasons in total. Again, it's down to the applicant to decide whether they wish to appeal that decision or come back to us with a revised scheme, and we await contact from them. And then finally on page 8, the third one down, which is a prior notification for a 20-metre high telecommunication mast at Simmons Bath. You can see that this was submitted as a prior approval application, so that is where the principle of the development is established by government legislation. But as part of that legislation, it says that there are matters that need to be agreed and shared with the planning authority, which look around sort of its siting, its landscaping, etc., etc. In this instance, we felt that actually it was located close to the main road as you drive out of Simmons Bath towards Dorverton. It would be quite prominent within the landscape, both at close by views, but also some more distant views looking back across. It had followed a previous application for a similar prior approval on the other end of the field, but it was felt that this application didn't overcome those original reasons for refusal, so it was refused on landscape impact grounds. We have had notification that an appeal has been submitted for that site, so we await start date letters for that in order for us to prepare a defence to that decision, and we will obviously keep you informed of the decision if and when it comes. So that's the edited highlights, as you put it, Chair, and I'll take any questions on any other if it's helpful.
No, we can go for the edited lowlights. Can I just say that the little yellow sticky that was passed to me by Mrs. Coles was, can please members put their hands up properly? Just in case you were wondering. Yeah. Just so she knows that she can take notes. Right.
Just one at a time.
Indeed. Page 1. Anything that members want to raise on page 1?
Yes, it was.
Yes, Mr. Milton.
Was 2 or 3. I see there's quite a selection of discharge of condition ones for Linton and Barnstable Railway Trust, starting on page 1. I didn't know whether you could give us any further information.
Yeah, so this is a fallout of the previous applications that we received, the Section 73s that have since been withdrawn. Once they were withdrawn, we invited the applicants to withdraw these applications, but they decided not to because they felt that the responses would be useful in terms of the information it provided. But we are merely working through those applications and providing the decisions. I think we've only got one left now, but yes, they are slowly coming through.
That's why I didn't understand what they were about. Thank you.
Anything else on page 1? Page 2? Page 3? Page 4? Page 5? Page 6? The one from the bottom that Mr. Kinsella drew attention to, Bradley. That one is of some potential significance because I think if that one had been allowed, it would have been a very considerable precedent for other sites elsewhere in the park. So that one is well worth taking note of. Yes, sure.
When you spoke about that earlier, you talked about light pollution. It's probably in all the policies somewhere, but have we got something in the policy about light pollution? Because there obviously a dark sky is there.
Yes, so we've got specific policies dealing with it, and the reference is CES2, Protecting Exmoor's Dark Night Skies. So it's a policy that covers the whole of the national park, although there are dark night skies reserves that are designated sites, and then you have buffers around it. But the policy contributes to the whole of the national park, and it's all about ensuring that development is designed in a way to limit that external glow that you can get. I guess the easiest way to put it is your grand designs type of proposals where they get lots of glass and then there's light emanating from it, and you can see how that has not just an impact upon the dark night skies, the character and appearance of the national park, but also things like wildlife. You know, it can have quite a significant impact around that. And it's considered in this instance that the design saw quite a lot of glazing in the one elevation in particular, which was designed to, as you'd expect, take benefit of the views, and it was felt that alongside that there would be quite a lot of light emanating from the structure.
And whilst it wouldn't prejudice any application, of course, moving forward, if there were applications with a lot of glazing, they would most likely fall foul of that, is that what you're saying?
We would certainly have concern, and we would want to be looking at those carefully.
Okay, page 7. And page 8. Dr. Kelly.
Chair, I'm performing an invaluable role as spell checker here. So if we look at 643-23002, listed building, it refers to repairs to plank and munition screen. Now, I'm not sure what that is. It might mean Munson screen, but it's not a munition scheme, I don't think. Well, it may be, but I thought I'd point it out. Do clarify.
I will look into it and rectify.
Thank you for firing off with that one. Anything else then on the delegated decisions? Because these are important for us to go through. It's important for us to understand what has and has not been passed, not the least because many of us will have to report back to our several parish and town councils about where permissions are at the moment, where applications are, and it is important to understand the reasons why some of them have not been approved. Yes, Mr. Wilson.
On that, in the spirit of that, it's a question really from the list and from other things you're seeing coming through, only reaching back to a discussion we had probably over a year ago now about renewable energy upgrades and retrofitting, obviously becoming increasingly in the news now and in people's interest, and also as part of our climate emergency. Have we seen any more of those sort of coming through, like air source heat pumps being put in? That's probably more likely for listed building consent, but of anything of that nature, or has it just not really fed through yet?
No, I think there is a trend towards maybe not specifically dealing with renewable energy, but actually them being incorporated within schemes. So there's quite the National Trust does have a bit of a drive towards it. So secondary glazing in some of their listed buildings, the use of air source heat pumps. We've noticed that quite a few of the agricultural buildings now are coming in as standard with solar panels on the roof, looking to provide energy within there. And we're trying to, through the work we're doing to create the design guide, the work that we're doing to create the new validation checklist, and through just general discussions, trying to, I guess, lift up the priority of that in the discussions that we're having around design. So before you start thinking about technology, let's think about the building, let's think about the orientation, let's think about some of the things that we can harness before we need to worry about the mechanical side of it all. And I think that's sort of a natural flow that we're going into when we're talking to applicants now. And again, it might be more of the subtle thing, but we will try, especially when we're presenting schemes, maybe to talk about that a little bit more in the months to come when some of these schemes start to come through.
Okay. Right. The date of the site visit, should there be required, will be Friday the 28th of July. If there is a need for one, and that therefore brings that part of the planning meeting to a close, as we've been deserted by the authority chairman, who I would normally hand over to at this point. I can either hand over to you, Mr. Deputy, or I can formally close the meeting, which I now do. Thank you all very much, ladies and gentlemen.